make this whole thing up because they were trying to shake the defendants down for money. Those are the charges on the table, and in order to talk about them, we have a guest with us here. Marci Kratter is a criminal defense attorney out of Phoenix, Arizona. She's joining us on the LawNewz Network. Marci, good to see you.
Nice to see you too, Aaron. Thanks for having me.
Okay, so a lot has happened in this case in the last couple of days, so I'm trying to get a sense of exactly where things went. You know, what do you make of some of these accusations? I mean, witness tampering is a felony in and of itself.
Sure, but it's not at all surprising. Having done criminal law for 20 years, this is not that unusual that you're going to have a situation where there's an allegation that one of the witnesses or all of the witnesses will be operating, they have some kind of bias. And so the jury's job is going to be to assess their credibility. If it was a clear-cut case where these witnesses were pristine, it would likely not be going to trial. The fact that it's going to trial suggests that there was something that the state did not know about or was not willing to recognize. And that probably had to do with the witness's credibility.
It seems that the lead detective in this case, Detective Santos, only found out about these allegations of witness tampering within the last couple of weeks. That's a little bit surprising in and of itself.
Not necessarily. I mean, I think the police do the best job that they can under the circumstances, but this isn't the crime of the century. It's not a homicide. It's not a child molestation. You know, they have limited resources, and to their mind, this crime has been solved. We found the bad guys who did it. And oftentimes it's the defense's job to go find out about these witnesses. You know, all the state gets, the prosecutor gets a Form 4, which is a probable cause statement, which will give a synopsis of what occurred. And they'll get a police report later, but they don't know what's beyond the paper. And so that's the job of a defense attorney, is to figure out who are we really dealing with. I mean, they're more than just a name. I mean, who are these people and what is their motivation? And unfortunately for professional athletes, they're kind of sitting ducks.
So do you buy some of the accusations that the defense is throwing out here, that maybe this victim and at least one of the witnesses, if not several of the witnesses, may just be trying to shake these guys down because they're in the NBA, because they have multi-million-dollar contracts?
Absolutely. I mean, I've seen people come into court and lie for less than that. And so you can't ever really understand people's motivation. And I'm certainly not suggesting the witnesses are lying or making it up. I have no more information than the casual observer who's watching this trial. I know nothing about these people. But if there wasn't a real possibility that witnesses lie, there wouldn't be a standard jury instruction that explains to jurors that it's their job to weigh the credibility of witnesses, and they're directed to look at things like motive, bias, potential gain. If it didn't happen all the time, there wouldn't be a standard jury instruction on it.
I'm sure that the one in Arizona is similar to the ones we have in other states. In your experience, though, if there are accusations of witness tampering, I'm not aware that any charges have been filed about it in this case. Would you expect them, or do you think that the police are just going to let this go?
Well, I think it really depends on the outcome. And so what I imagine will happen is it depends on the verdict, and it depends on what the jury feedback is. So let's say the men are acquitted, and in Arizona, the lawyers can go back into the jury room and discuss the case with the jurors. And those jurors say, I didn't believe them. They were so incredible to me. We thought they were liars. We thought they were working the system. I think there's a possibility that the state goes back and charges them, as they should, because they put the defendants through this horrible crucible, cost them tons of money and bad publicity, and cost the state of Arizona money. I can't imagine the state on its own is going to move forward and charge these people unless there is a conviction, an acquittal.
Well, that's an interesting insight, and you're the one who practices locally. I know that when we talked a little bit earlier today, you said that you had at least some experience with the judge who's on the bench. She strikes me as very smart, very able, and very fair. Has that been your experience as well?
Absolutely. Incredibly pragmatic, looks just very even. She's got a wonderful temperament, completely even, doesn't get drawn into some of the courtroom drama that happens, is able to detach herself and behave professionally. And I think what's more important is she really doesn't, she's not biased. I think she kind of calls it the way she sees it, which is not always the case, because sometimes when judges come from a prosecutor's office or a defense attorney's office, they have this bias. And, you know, there's something that draws us to the kind of work we do. So if you're a prosecutor, something about you drew you to this work. And when you become a judge, you don't automatically divorce yourself from that part. I mean, it's there. And so it influences the way you see things. I think Judge Gates didn't really do criminal. I believe her background is civil. And she's very neutral. And I think she's incredibly well respected across the board. And I'm not sucking up because I appear there. It's true. I think you can ask anybody and they'd all say the same thing.
Well, I mean, that's my experience, and I sit and watch judges on benches in, you know, as many states as will allow cameras here at LawNewz, and then have some experience myself in states that don't allow cameras. And look, you know, most judges come to the bench through the track of being a prosecutor. The community knows them, recognizes the name, and in states where judges are elected, it's a pretty easy hop from a county attorney or district attorney, state's attorney, whatever you call it in that jurisdiction, to the bench, because the name is recognizable. And if people like the job that the prosecutor is doing, a lot of times the public opinion is, well, you know, they got the criminals off the street as a prosecutor, they'll keep them in jail as a judge. But it's not really that simple to boil it down to that kind of a statement. What you want out of a judge, or at least what I would think we all want out of a judge, is a judge who will look at the rules and say, this is when it applies, this is the circumstance where it applies, and then this is where it doesn't apply. You know, if somebody tries to bring hearsay into a trial, the judge recognizes it, responds accurately to the objection under the rule of law.
Right, and not because of the bad guy rule, or because their former prosecutor self wants to keep the bad guy off the street. So, you know, the goal is correct, so we'll just let this slide. A good judge understands the rules of evidence and applies those and kind of divorces themselves from who the person is, like who the defendant is, what they did. It shouldn't matter whether you go to trial on an excessive speeding case or a murder case. The rules of evidence should be applied the same way. And I think that Judge Gates does a wonderful job of really just ensuring that people are treated professionally and fairly in her courtroom.
Well, and again, that's what we would all hope out of all of our judges. You know, it's interesting that she came into this from a civil track, though, because it's a bit unique, and then B, she's right on top of the issues. So she's clearly very, very smart. I can't recall seeing any other judge who's more on top of things than she is.
Oh, she's always prepared. And let me add one more thing, that because I'd like to add a C to your A and B.
Okay.
A lot of times what people coming from civil lack is perspective. So they have been law-abiding citizens their whole life. They have no interaction with the criminal justice system. And so they don't have perspective to see how bad is this compared to other things. I mean, every crime some of these judges see coming off of civil is horrific because they really haven't seen the breadth of things that can happen. And so she's also great in that she kind of is able to apply common sense and figure out, is this the crime of the century, or where does this fall in the spectrum of criminal activity?
You know, and I know some of our viewers have jumped and said, well, you know, this is just an aggravated assault trial, and part of the reason we're interested in it is because we have a couple of NBA players on trial, and so a lot of people are watching it. One of the things we've talked about a lot here on LawNewz is that the end game for the defense attorneys, at least for the Morris brothers, Marcus and Markieff, is not necessarily the conviction, it's how the conviction would affect their duties, obligations, and punishments under the NBA player contract. So when a criminal defense attorney is representing someone who is also under an employment contract, whether it's in a professional athlete venue or it's with a corporation, the end game is not just what happens in that particular courtroom, it's also what's going to happen under the employment contract. You know, is there a moral turpitude clause? Is there a clause that says if you get a criminal conviction, no matter how slight, you're gone as an employment matter? Or is it the kind of contract that says you're gone if it's a felony, but if it's a misdemeanor, you might face some lesser punishment? So I'm sure that the defense attorneys, I mean, they obviously have that going through their minds as well.
Sure, and we always do. And so just to be clear, and this is a point that, I feel like I have to drive home all the time. A lot of times prosecutors will be looking for jail time or prison time in addition to a felony conviction. And we have to constantly remind them that a felony conviction in and of itself carries huge implications. And so while I have not represented any professional athletes, I have represented teachers, truck drivers, nurses, all sorts of people who, like, so if you're a nurse and you have a substance abuse issue and you get caught with drugs or doing some kind of prescription, messing around with prescriptions, you lose your job. You can't practice anymore. If you're a truck driver and you get a DUI, you lose your livelihood. If you're an educator and a kid accuses you of something that you didn't do, you're going to lose your job. So while I understand, obviously, this is interesting because these guys are professional athletes, a lot of people, most lawyers have more to consider than just the conviction, because a conviction begins a spiral, a snowballing effect that's going to impact your life forever. Credit, where you can live, who will employ you moving forward after you lose your job. So it's a huge consequence. And I'm sure the lawyers are thinking about that.
Oh, certainly. I think we talked a little bit about this before. Do you have any experience with any of the defense counsel here? Because keep in mind, we've got two NBA players, and then you've got this third defendant named Gerald Bowman. So he's an associate of theirs. And then you've got two other people who already entered guilty pleas, and the word on the streets is that at least one of them is going to testify later today as a defense witness. So that gets really interesting in and of itself.
That really gets interesting, because a lot of times if you take a plea, particularly in Maricopa County, if you're a co-defendant, in order to plead guilty to a crime, your lawyer needs to provide what's called a factual basis. And a factual basis is, what did you do that constituted a crime? And you have to admit to doing that. Oftentimes when there's co-defendants, there's a provision in there that says that you saw this person do it, you are making this statement under oath, you're aware you could be charged with perjury should you change your story, or that you won't come in and testify for one of the other co-defendants. So I'm really surprised that the plea would not address that.
Well, you know, I'm curious, because what if this person who admitted guilt says, yeah, it was myself and one of the other people, but it wasn't these other ones? Then that's a whole mess of trouble for the state.
Yeah, and it's something they should have contemplated. You know, that's part of the strategy of trial, right? Like, what are your witnesses going to say? And this is not, the fact that a witness would do that shouldn't surprise anybody. I mean, you should see that coming a mile away. So it would be interesting to see what his plea actually said.
Yeah, I'm really curious to see where that goes. And I know that I sort of rolled a multi-part question together there. Sure. I'm surprised you didn't object. You can always object to my questions if I'm asking compound questions.
Compound question.
But we started to talk about the defense attorneys a little bit. Have you had any experience working with them?
I have worked with them, not on cases together with co-defendants, but they're excellent attorneys. Everything I've heard about them is excellent. Jim Bellinger is a great lawyer. Tim Eckstein's a great lawyer. Kerry Lackey, I think, is a former prosecutor. He's been a defense lawyer probably for the last, 18 years or so. I mean, they have fine lawyers. So this is not a situation in which these men don't have good lawyers.
Certainly. They're I mean, compared to some of the other cases we've seen here, and if I need to be critical of the way a case is being tried, I do so. In this
please
case,
invite me if that's going to happen, because I'd like to get in on that.
But in this case, I think the lawyering has been very, very sound. The motions to dismiss last night were very sound. They were rooted in legal arguments. There were cases cited. And of course the judge denied them, as a judge does 99.999% of times after the state's case in chief. But, look, I looked and said, okay, this isn't just some off-the-cuff, willy-nilly, half-baked attempt to get a case dismissed. This is something that's been backed up with some research. And, the judge said she didn't want to make findings on the record as to why she was keeping it alive, because, that would sort of maybe give the prosecution a tip of the hand, but she did say she would put them on the record in writing to be part of the appellate record. I thought that was a little bit interesting. Is that the way it's usually done in Arizona, or is that unique?
No. Sorry, I didn't mean to interrupt you.
Okay.
So I think is this, has the state rested?
Yes, the state rested. There was the standard motion by the defense to dismiss the case after the state's case in chief, and she said, I'm keeping it alive. She said a little bit about the standard, there's issues of fact for the jury to consider and whatnot, but she didn't make a clear set of findings on the record as to what exactly she thought the factual discrepancies were, but she said, at least she didn't say them in open court. She said that she would make the findings of fact in writing if necessary for the appellate record, and the defense thought that that was a good way to go. The only thing that came off the tip of my mind last evening is that maybe she wanted to do it that way to not sort of give the prosecution a sense of what she thought was, or what she thought were the strengths or weaknesses in the case. But it was a little bit different than what I've usually seen.
Right, and you're right. 99.999% of the time, these motions are not granted; they're denied. And so, I don't know how it is in the rest of the country, but in Arizona, we have this motion for a directed verdict at the end of trial. It's called the Rule 20 motion.
Yes.
And basically, you're just saying that the state has failed to prove their case. It has failed to present substantial evidence that this, in fact, happened. Typically what happens is the judge listens to you because, this is kind of the procedure of going through trial. This is what you do at this point. And summarily denies your motion. I have not had a situation. I have had judges grant my motion for directed verdict, and they'll explain why. I have not had a judge withhold the reasons why. And I really haven't had a whole lot of time to think about why one would do that. And perhaps ultimately her ruling will reveal why she felt the need to do it that way.
Well, that's certainly something that I'll have to keep in mind if I get a chance to question any of the litigants in the case. I was under the assumption that maybe it was because the defense didn't want to sort of like tip a hand to the prosecution as to what the strengths or weaknesses of the case may have been. But again, it's like the facts are on the table. They're on the table. We know what's going on by the point it gets litigated. Well, we sort of kind of do. It seems that there's still a lot swirling in the background here about whether or not witnesses are lying and whether or not witnesses have been asked to, concoct a story or cover for somebody. Like, that is really an active part of this, and a lot of this seems to have been discovered in the last couple of weeks.
Yeah. Well, and you know, with the defense attorneys, obviously, they're not going to go around telling people about the problem with the state's witnesses that they've revealed. I mean, that's part of trial strategy. And so that's why you don't hear it until you're actually in trial. Why would you give the other side an opportunity to prepare and shoot down your strategy? So I'm just kind of puzzled. I agree with you. I mean, it's kind of all out there. I would imagine that every one of those lawyers did an exceptional job with cross-examination and left no stone unturned. So I don't really know what's there. And what I imagine the judge would say is, look, if this is a question of witness credibility, that's for the jury to decide, not me.
You know, one of the big arguments here is that really the only person placing the Morris twins in the fight is this Sharika Sherrod, and she's a friend of the victims. So I want to listen to some of the testimony of the lead detective about how the police department tried to figure this out. We're going to go there, and we'll be back with more analysis in just a second.
Yes. You know, you understand that they pled guilty in this case to the charges that were lodged against these defendants, correct?
Yes, I understand that.
You heard Mr. Halal's in-court testimony. You were sitting here as the case agent.
Yes.
And you know Mr. Halal, he was the assistant coach at Westwind Academy.
Yes.
Okay, and he described that he saw one person involved in the fight at the end of Coulter Street. You remember that?
Yes.
And he described that person as being a little guy, about 5'8" tall.
Yes.
Correct. Right. And you are aware of the, you know who Christopher Melendez is, correct?
I do.
And you're aware of the fact that he's approximately 5'8" tall. I think you told on direct examination, you said that you interviewed approximately 30 or 40 people in this case.
Yes.
And you had conducted at least, we've gone through this before, 2 interviews with Mr. Hood. There were more than 2 interviews, but there was one on the right after midnight on January 25th of 2015, correct?
Yes.
And then there was another one on January 26th,
Yes.
a couple of days later. And on that January 26th interview, Mr. Hood, after having told you at least 8 or 9 times that all 5 defendants were involved in touching him and hitting him in the fight, he changed his story and said that Markieff Morris was somewhere substantially removed from the fight, didn't he?
Yes, he did.
And that was after an approximately 13 or 14-minute telephone call with what he described to you as his lawyers.
Yes.
And did you ever ask him to name the people that were on that telephone call?
No.
So you have no idea who was on that telephone call?
No, I don't.
You could have asked him who was on that telephone call, correct?
I could have, yes.
And it could have been Alonzo Hickerson.
It's a possibility,
Because
yes.
he was telling you, when he was relaying that conversation, that not that his lawyer was telling him what to do, but they were telling him what to do. The persons on the telephone call, they were telling him what to do in terms of your interview, correct?
Yes.
You also indicated, and this is, you had spoken to Ms. Sherrod, and she described what she described in terms of right outside the gymnasium, there was a fight and a bunch of people were involved. Do you remember that?
Yes, I do.
And you said you interviewed approximately 30 or 40 people in this case, correct?
Well, not me alone. I had 2 other detectives that assisted.
You're the case agent.
Yes.
You're familiar with every interview that was done in this case, correct?
Yes.
You reviewed the work that was done by the people that you were directing to investigate this case?
Yes.
And you're aware of the fact that there was not a single person that corroborates what Sharika Sharad said?
I would object hearsay. He's asking about what other witnesses have relayed to him.
Overruled.
Yeah, that's correct. There was no corroborating information.
No other witness, the entirety of the investigation, that corroborated what Sharika Sharad said happened outside of the doors of the Arts Gymnasium, correct?
No other witnesses, that's correct.
And Eric Hood had told you that, notwithstanding what he had said several times before, that Markieff Morris was not involved in the fight, correct?
That's correct.
And he also said to you that at the doors of the gymnasium or up by the Arch building, he got hit in the head, he got punched, correct?
Yes.
And that as soon as that happened, he sprinted approximately 300 yards down to Coulter Street, correct?
That's correct.
And even though you had interviewed 35, 40, 30 witnesses, that none of them supported what Ms. Sharad had said, and the victim, Mr. Hood, who told you that he could tell these two guys apart basically in his sleep, told you that that assault never happened outside of the doors of the Arts Gymnasium. There was no big fight there. You never went back and checked again with Ms. Sharad regarding what she told you, did you?
Objection, Judge. First of all, he's asking for a legal conclusion in terms of an assault occurring outside of the gym doors.
Just rephrase your question.
Okay.
Sustained.
Ms. Sharad described some kind of mayhem involving many people outside of the gym doors, didn't she?
Yes, she did.
And Eric Hood described being hit in the head inside of the foyer of the gymnasium, correct?
Yes.
And then he said there was never any fight outside of the doors of the gymnasium, did he? Did he?
Objection. I would ask for clarification. He's talking about outside of the gym doors,
Yeah.
just to be more specific with the witness.
Mr. Hood never said, after he was hit in the head and sprinted 300 yards, he said he was never assaulted again until he got down close to the gate at Coulter Street, didn't he?
That's correct.
And you never went back, notwithstanding all of that, you never went back and did any other interview with Ms. Sharad?
I believe I did. I had approximately 3 interviews with her.
You think you did?
I believe so.
Okay. Do you have,
Have anything
were
anymore?
the exhibits collected?
Yes.
I'm sorry, it's a Detective Santos interview, the one that you just used. But it was 180. Yeah, it was the one that you did. Gotcha.
That was a clip from earlier in the case of the lead detective, and Marci Kratter, a local criminal defense attorney in Phoenix, is still with us. Misty Maris, my co-host, is also still here. I'd like to bring Misty into the conversation. Misty, you listened to some of the testimony this afternoon. We had this barber or hairstylist, whatever he calls himself, and what was his relevance to all of this?
Well, so interestingly enough, Aaron, we've been focusing a lot on the Morris brothers, but there is a third defendant in this case, and that's Gerald Bowman. Now, the barber was testifying about cutting Bowman's hair on the date of the incident, and in doing so, establishing that Bowman had an alibi and was not involved in this altercation. During the defense portion of the questioning, it seemed pretty rock solid. There were some photographs of some of the hair he had cut earlier in the day. No photograph of Bowman. This guy takes cash. He was new to cutting hair. He does it in someone's home. No paper trail, let's put it that way, regarding Bowman being in, getting this haircut at that time. However, came out later during that examination that guess what? There were some text messages exchanged between the barber and Bowman. That was an issue. The prosecution didn't have the text messages. It seemed there was an evidentiary dispute. Ultimately, the prosecution continued their cross-examination, and the focus of the cross-examination was, well, did this really happen in 2015? Because these text messages between Bowman and the barber, while being stamped for a date, the January 25th, did not have a year. So they said, well, aren't there 2 other Januaries where this could have occurred? How many times have you cut Bowman's hair since then? And do you remember any other instances? And it turns out he only remembers that one day. So that's where we left off during that cross-examination. So it's just establishing an alibi.
Is this just a wash then? I mean, is it possible to just take that and say this doesn't make any sense, Misty?
I think that really from this perspective, it seems that Bowman has not really been the focus, so this is really something coming to the forefront that he may have a complete alibi in this case. But right now, I think we're still in the midst of that cross-examination. It's going to be interesting to see where the prosecutor goes, because really they're just trying to cast doubt on the fact that these text messages and this haircut happened on that day.
Yeah, I mean, that's an interesting one. And Marci, one of the other things that we're hearing might come out of this is that there are some witnesses who say Markieff Morris wasn't directly involved in the attack, that he was sort of hanging back with some other people. He may have been watching it. He was present, according to some of these witnesses. Now, some say that he was acting as kind of a lookout, holding rescuers back. And others are just saying he was hanging out, not wanting to get involved. But there's only one witness, really, putting Markieff Morris, one of the NBA player twins, in the skirmish going on. So is it possible here that we could see some really weird split verdict where the jury could look and say, I'll discount Sharika Sharad's testimony and go with some of the other people who don't put him in the fight, and then convict his twin brother Marcus?
Sure. I mean, there's nothing that prevents the jurors from believing 1 or 2 or none or all of the jurors. Remember, it goes back to that jury instruction about credibility, and it's up to them to assess who they're going to believe and not believe. So it's absolutely possible that one of the brothers could be convicted and the other acquitted. It's also possible that the jury could say, hey, we're not sure, and that in and of itself is reasonable doubt. And I mean, if I was the defense lawyer, that's what I'd be arguing, is we have no idea what they did or didn't do or which one of the brothers did it. And that in itself is reasonable doubt.
Yeah, now we've got that. We've got confusion as to whether or not the brothers were even part of it at all, because some of the independent witnesses are saying that they thought it was people who were maybe about 6'3" I forget the exact numbers. They gave kind of a range. Well, I'm 6'3", and guess what? Not that I ever wanted to, but I'm not tall enough for the NBA. The Morris brothers are like 6'9". I mean, they're all way taller than I am. So maybe the jury could turn around and say, look, the only unbiased witnesses in this room are the people who were at this rec center on the side, who just happened to see the victim running and then this pack of people attack him. It was dimly lit. They didn't really recognize anybody, and they thought that the heights were off. I'm sure the prosecutor will say, well, I mean, yeah, how can you really tell how tall somebody is from from far away on a dark street at night? But it's possible the jury could look and say, hey, we just don't have enough eyewitness testimony to put them both in that attack.
And assuming they even did have eyewitness testimony, I'm sure the defense is going to talk about the unreliability of eyewitness testimony and how sometimes you'll hear about something later and it will alter your memory of what you saw earlier. And I think eyewitness testimony is one of the least credible forms of evidence there is. And I don't know who these witnesses are, but then you're getting into cross-racial identification potentially. That's a whole nother problem. There's experts that'll come testify about problems with eyewitness testimony, which gets exponentially larger when we're talking about cross-racial kind of stuff.
Yeah, Misty, I mean, who do we believe here? Do we believe the people who say that one of them was involved and one of them wasn't? Do we believe the friend that carted the victim off to the hospital and then bragged that she was going to get a kickback from the settlement? Do we believe both of them? Do we believe neither of them? I mean, who do we believe?
Right, and that's really it, Aaron, and that's what the jury is going to be parsing through, because they're ultimately the deciders of whose testimony they believe is credible. But I get excited talking about this case because there's reasonable doubt abound. You guys made some great points talking about some of those eyewitnesses that don't have anything at stake, not being able to identify the heights of the people involved. Now, no offense, Aaron, I'm sure you're great at basketball, but
I'm not, actually.
6'9"
I'm terrible. I let it be known I have zero athletic skill when it comes to basketball. I am taller than you, but I have no basketball skill whatsoever.
Right, so you're taller than me. You're 6'2", 6'3".
6'3".
You're 6'3". I don't think you're 6'9". 6'9" is a really big difference. And when you're talking about casting reasonable doubt, that's all you have to do from the defense perspective. Other points that you brought up, you have two twins here. So in that scenario where you may have one that could have been involved and another that could have been, and another that wasn't, you have a big problem from a prosecutorial perspective because that alone could raise reasonable doubt as to both. So there's so much fodder here for the defense to latch onto, and even complicated more for the prosecution by some of this witness testimony that was very self-serving.
Yeah, Marci, question for you here. Now, let's say that the prosecutor is going to try to continue to sell this theory that Markieff Morris either was involved or under one witness's version of it, or was sort of hanging back to prevent aid from being rendered in another possible theory. I will put you on the spot a bit here as to the local law in your jurisdiction, but is it possible for the state to argue both sides of the same coin? Is there sort of an accomplice or a lookout to an assault charge that would stick here?
Sure. I mean, if we were talking about he was just there and he didn't do anything, there's no criminal liability, right? You don't have an obligation to do anything. I think when you prevent somebody from getting help or rendering aid, that's when you start getting into criminal territory. So it would be interesting. I'd like, pardon me, to see the indictment, see the way it was charged. If you'd be put on notice if there was an accomplice liability theory, because they cite the statutes, and the statutes would have to reflect that accomplice liability was there. Although I don't know why. You know, if you think about it, it's mostly just an issue of being put on notice. Was the defense on notice about what the claims are? I don't know. I don't know. It seems okay to me, but I'd want to see the indictment.
Yeah, and I think that there was a lot of discussion last night about whether or not the state was going to try to pursue both theories or whether the state wasn't. And I don't have a copy of the indictment in front of me just this second, but maybe the next thing I need to do is dig one up, because it seemed that the state was trying to push both. Maybe I misunderstood it a little bit. I think they're primarily trying to go for the aggravated assault conviction to try to convince the jury that Sharika Sharad was telling the truth and that he was involved. I think that's their hope. But part of me wonders if they're trying to fall back on something else. And look, the defense was even trying to figure out last night exactly where they were going to go with this. Because it sounded last night like the Markieff Morris's defense attorney was considering not putting a case on at all and just saying, hey, look, the only person who said for sure that he was involved was Sharika Sharad, and she was bragging to her buddies she was going to get a kickback in response for her testimony. Discredit it right off the bat. Don't even listen to what she has to say. She's lying for money. Yeah.
And, you know, that's a call we have to make all the time as defense attorneys. Has the state either inflicted enough damage, do they have enough self-inflicted damage that we don't need to put on a case? Or should we put something on? Because even though we know jurors that are instructed that the defense doesn't have to do anything, we know in the back of our minds they're waiting to hear your side.
Yeah.
And
so you're afraid not
to.
You're afraid not to. But again, you know, look, how many times have you defended someone, Marci, where you haven't put on a defense, where you have just looked and said the state's case falls apart on its own?
The majority of the times, I have to say, there was not an affirmative defense. The majority of the time, and that has to do with charging. So a lot of times, the county attorney's office will overcharge things. As a strategic thing, they want as much leverage as they can against the defendant. Well, if you've got a client, if you think their case is going to fall apart because it's overcharged, you know you don't need to put on any evidence to prove that. You could just pull apart theirs, because they're the ones with the burden, and if they can't prove it, you don't really need to put anything on. But you're right. It's such a difficult decision to make whether is that enough? Was what we did to the state's case enough, or do we need to add some of our own?
Well, I can tell you from what I heard last night in the motions outside the presence of the jury that the defense was indeed wrestling with the possibility of one or the other. And the judge is like, well, you need to think about what you're going to do, but you all need to get together and figure out who's going to call what witnesses and when, because we have to move on tomorrow, and you need to make a decision pretty quickly here. So that seemed to have been the general mood in the room last night outside the presence of the jury when they were hashing these over. Misty, if you're defending somebody, are you sweating bullets just trying to make the whole case about reasonable doubt and not calling a single witness for your client?
It is such a strategy call, Aaron, and it's so situational because in a case like this, I was actually kind of surprised that they did move forward and call witnesses. There's enough here to establish that reasonable doubt. As a defense attorney, you don't have to do anything. You're right. It's more about jury impression. And is the jury going to think there's something wrong with your case because you didn't put any witnesses on the stand? But you have to remember, from a defense perspective, if there are those holes in the prosecution's case, if you start putting on your own witnesses and you get a little bit of a surprise that you didn't anticipate, you may now have opened up a can of worms, and the jury hears something they can't unhear, and you could have been the one that throws the wrench in the whole case because you could have prevented that from moving forward, because you don't know what's really going to happen when even witnesses you think are going to be great for your case are on the stand.
I want to listen to some of this testimony today from Joshua Joe. He's the stylist barber who was called as a alibi witness for Mr. Bowman, who is the third defendant here, who we don't really talk as much about because Marcus and Markieff Morris are sort of stealing the show in this case. But he's trying to claim, hey, look, this guy couldn't have been involved because he was getting a haircut with me. Well, it's kind of interesting. I'm wondering who gives haircuts at night when basketball games are usually going on, but I guess it's possible. So let's listen to some of his testimony from today, and we'll be back in a bit.
My name is Joshua Joe.
And Mr. Joe, what do you do for a living?
Barber, stylist.
And how long have you been in that profession?
I've been a licensed professional for about 3 years.
Okay, and you remember when you got your license?
About 3.5 years ago.
Okay. And you say you're a barber and a hairstylist. So back in 2015, you had your license and you were cutting hair, correct?
Correct.
What type of barbering, if you will, were you doing back in 2015?
As far as the service?
Correct.
I was providing a mobile service.
And what's a mobile barber service?
Basically, a client would call me, and I would show up and take my services to their home.
And so you would go and set up and perform the barbering services there, right?
Correct.
Okay. Would the person you put a cape on them and?
Absolutely.
Okay. All right. And how do you know Gerald Bowman?
Gerald was a client of mine.
All right. And when did he first become your client?
I was referred to him, I think the first time I cut him was the 24th of January.
Of what year?
2015.
And that was that haircut performed in Phoenix somewhere?
Yes.
Do you remember where exactly you were when you cut him that first time?
North Phoenix, it's Cave Creek and the 101.
That was the exit that you took to get to where he was staying?
Yeah.
Was he staying was it in a house or an apartment?
Apartment.
Do you know why Mr. Bowman was in town?
Yes.
What was he in town for?
He was in town training for the combine, the draft.
Okay. And was that NBA or NFL or NHL?
NFL.
All right. And so at some point, did Gerald, prior to January 24, 2015, or maybe even that same day, did he reach out to you and ask you to cut his hair?
Yes.
Now, as far as, this might already be kind of academic, but back in January 24th, or January of 2015, would be fair to say that this was kind of the beginning of your barber career?
Yes, I was young in the game.
Okay. And let me back up 1 second. Mr. Joe, where are you from?
Flagstaff.
Flagstaff, Arizona?
Correct.
All right. You ever spend any time in North Philadelphia?
Never been.
Okay. All right. So prior to cutting Gerald's hair, you didn't know him?
Never.
Okay. How many times after January 24, 2015 do you think he cut his hair?
3 to 4 times.
And were all of those times here in Phoenix?
Correct.
Do you know whether all of those times were while he was out here during the combine period?
It was.
Let me approach a witness, Your Honor.
You may. Mr. Bailey. Mr. Bailey.
Yeah, let's just focus it. Cut. All three of them.
Yeah.
Okay.
All right, Mr. Joe, I'm going to show you what have been marked as exhibits 209, 210, and 211. Are you familiar with those?
Yes, I am.
What are they?
That's my work.
When you say your work, what do you mean?
It's a haircut that I performed.
Do you know what date you performed those?
January 24th,
Do you know what year?
2015.
And is that a fair and accurate representation of the work you did, specifically a haircut that you performed on January 24, 2015?
Yes, sir.
Right. Move to admit those exhibits, Your Honor.
Any objection?
Judge, at this point, the state would object foundation. We would like to know information as to who's depicted in those pictures, anything in terms of identifying information.
Sustained.
Mr. Joe, do you recall the name of the individual in that picture?
I do.
And was this person an adult or a child?
An adult.
All right. And there's no, strike that. What's that person's name in the photo?
Jordan.
Okay. Do you remember the person's last name?
Jordan Holly.
Okay. All right. Your Honor, I'd move for the admission.
Any objection?
No.
Mr. Eckstein?
No objection.
Mr. Ballinger?
No, Your Honor.
209, 210, and 211 are admitted.
Permission to publish, Your Honor?
Granted. Would you like the lights dim, sir?
Please.
All you need to do is hit the button right next to the red. Yes.
I'm your approach witness.
You may.
Now, Mr. Joe, I'm going to ask you, why did you take a picture of this particular individual, the back of their head?
I took a picture of that because I thought it was a good cut.
And would you use that to advertise or to show to other prospective clients?
Absolutely, I have.
All right. And so that's 211. And, oh, I'm sorry, 211 back there. And these were, how did you take these photographs?
By my cell phone.
All right, and does it, and it had looks like there's a date on there, and you said it was January 24, 2015. And did it also timestamp it?
Yeah, it says there 5:58.
Okay. And I'll show you what's been marked and admitted as 210, exhibit 210. And is that same individual?
Yes.
And you took that picture for the same purpose you just told us about, right?
Right.
Okay, and what's the, what was the timestamp on this particular photo?
6:02.
Hey, Your Honor, if you could raise the lights.
I'm going to turn the lights on.
So, Mr. Joe, on January 24, 2015, at 6:02 p.m., was that was the last photograph you did of that particular individual's head, right?
Correct.
Where were you when you took that picture?
40th Street in Southern.
And is that where that particular individual, did he live somewhere around that around that area?
Yes.
And you had done a mobile cut of his head at that time? Of his hair, I should say.
That is correct.
And what did you do after you took those photos?
Gerald was my next client.
And what did you do, or where did you go?
The destination and the address that he provided.
And about how long did it take you to get from 40th Street in Southern to the 101 and Cave Creek?
About 45 minutes. I probably arrived at his location anywhere between 6:45 and 7.
All right. And what did you do when you got there?
I set up.
Do you remember who let you in?
A gentleman by the name of Rob.
And you know who Rob is in relation to Mr. Bowman?
I did not know.
Okay.
I just knew that he was there training as well.
All right. And so this individual, Rob, opened up the door and you came in and set up?
That's correct.
Okay. And again, this was around 6:45 to 7?
Ballpark. Could be, yeah.
And then what happened next?
Mr. Bowman told me that he was en route. He was, would be there shortly. Again, that Rob was there, that he would let me in. Shortly after that, Mr. Bowman showed up with bags from a mall, and I performed a haircut.
All right. And so anywhere from 6:45 to 7, maybe about, what did you say, 20 minutes later, Mr. Bowman showed up?
I couldn't be 100% sure, but, that could be.
How long back then did it typically take you to cut someone's hair?
Typically, I was young still, so, at least an hour, Could have been longer at that, with him.
Why would it be longer with him?
Well, that was a different level of clientele that I was entering. So, and I'm a meticulous, person as it is. I try to take my time with it.
All right. So would it be safe to say between about 7 to 8, you were cutting his hair?
That could be true.
During that time, did Gerald ever get up out of the chair and say he had to leave and go anyplace?
No.
What did you do after you cut his hair?
Back up, sweep up. I asked, I'm not sure who it was, one of them, where the broom and the dustpan was. I swept up and received payment, and I'm on to the next.
Okay, and when you say payment, back then, do you remember what method of payment you would use or accept, I should say?
At that time, it was cash.
All right. Gerald didn't stiff you, he paid you, right?
No, he paid.
Okay. And you said actually you'd maybe cut his hair 2 or 3 times, or 3 or 4 times, I think you said, after this particular event, correct?
That could be true.
Okay.
All I know is that the last time I took my 2 boys with me.
Okay. Your 2 boys, you mean your sons?
Yep.
Okay. All right. And Mr. Joe, did Gerald ever offer you anything to say that you were with him back on January 24th, 2015?
Nothing.
Okay. All right. So you testified truthfully?
Correct.
Nothing further here.
No questions.
No
So
question.
that was the testimony from earlier today of this barber talking about what he claims is an alibi for one of the co-defendants here, Mr. Bowman, who was allegedly along with the Morris brothers when this attack was alleged to have happened. But apparently his barber claims he was getting a haircut around the time or at the time that this attack is said to have happened. So Marci, look, I mean, now you've got an alibi for Bowman. Now you've got at least several witnesses saying that Markieff Morris wasn't even involved. You've got some other witnesses saying that he was involved, and this is just turning into an old-fashioned he said, she said.
Yep. And it doesn't sound good for the state. It really doesn't. I think there's problems on so many levels at some point that it makes you question the quality of the investigation. Because at the end of the day, all of these issues that the defense is raising, all of these problems that are being revealed, could have been eliminated if there had been a thorough investigation. And I think oftentimes it falls back in the lap of the people who did the investigation.
Yeah, you know, one of the points here that really stuck out in yesterday's testimony is this thing that got slammed onto the record by the lead detective, where, you know, he had a couple of points buried in what ultimately was nearly 2 days worth of testimony. He said in one area that the victim himself, Eric Hood, had said several times over again, yes, it was the Morris brothers, but then he changed his story at the end. So, okay, well, what is it? The victim's on the stand saying it was the Morris brothers. At first he said it was the Morris brothers, but somewhere in the middle he changed his story and said, well, I'm not really sure. So which is it if the victim doesn't know?
Right, and so, and you'll have to help me out here. So the detective, was it during the detective interview that Eric Hood started out with Morris and ended up with he didn't know, or is that what he testified to?
No, he was in the detective interview at some point shortly after the crime. He's like, oh, yeah, it's Morris. And then he's like, well, I'm not really sure, but I think, or I don't know. And then on the stand, he's like, oh, yeah, it was the Morris twins.
Right. That's problematic, right? Because, you know, somehow the system bringing these charges forward and going to court month after month kind of solidifies in his mind that it was them. But if you go back to the initial statement, which is I'm not really sure, right? The process kind of cements it. This is something that the detective should have dealt with immediately. Like, what do you mean you don't know? You just told me it was. So why are you now telling me you're not sure? What do you think happened? Because really, that's what justice is all about, right? I mean, not just kind of getting some suspects and walking away. It's vetting your victim, vetting your witnesses.
Exactly. Now, there's this other little nugget that came out yesterday, and I don't know if it was really fully developed on the fly. I think that it's the old cross-examination technique of the way my trial advocacy professor used to explain to me. On cross-examination, you're not trying to prove a case, you're trying to collect little gold coins, was always her phrase, and I used to think it was tacky when I was in law school. No offense, Professor Keshen, but I understand your point. You collect the coins and then you cash them in when you're closing an argument, and you say, hey, look, this may have been one of them. Apparently the police recorded 37 witnesses to this attack. Well, there sure as heck have not been 37 people called.
So where are the rest of them? When they recorded those interviews, were the other witnesses saying it wasn't them, or I wasn't sure, or I don't know? Because let's say you have 37 and 5 give you some version of it was them or it was one of them or whatever, you still got a problem because the other 32 are potentially exculpatory, right? They couldn't identify them or they didn't identify them. And so that's something that absolutely needs to be addressed, and the jury needs to be aware of that. And you argue in closing, where are the rest of them?
Yeah, exactly. I mean, you've got that discrepancy. There are just discrepancies after discrepancies after discrepancies here. So I want to dial a little bit further back into the testimony here, because this I think was the key point when the trial started to crack. We've analyzed it many times over again, but this is so important, it's worth continuing to look at. This was really the first major chunk of testimony where one of the witnesses said that there was a pressure from someone else, a third party who is alleged to be an associate of the victims, to lie. Apparently the associate of the victims asked this witness to lie about what he saw, with the suggestion that if the victim gets a recovery in a subsequent civil suit, that there would be a kickback payment to this particular witness. So this witness was one of the AV techs at this youth basketball game where many of these people were in attendance before the attack happened. It's so critical, it's worth listening to again.
When you get down there, do you see anyone?
Yes.
All right, who do you see?
The lady who initially told us that there was a fight going on.
All right. Do you see any vehicles down in that area?
There was a vehicle, which I think was her vehicle, parked on the street, and she was helping him up off the ground, and helping him, and she was bringing him to her car.
Okay. Do you remember if anyone else was with them, those two individuals?
No, I don't remember.
Okay. And is it you, Jacob Miller, and Joe Murray down in that area?
Correct.
At any point, did you call the police?
No.
Do you know if the police were called?
I don't, at the time, no, but I believe that...
Objection, Your Honor.
Sustained.
And when you see the individual that was getting beat up and the female, what do they do while you're down there?
The individual, what does he do?
Yes.
I don't even know if he was even speaking or anything. I think he was just, he had just gotten beaten up, so she helped him get to the car.
How does he appear to you?
Beat up.
Okay. And when you say beat up, what does that mean?
I couldn't see his face close up. I mean, by the time we had gotten out there, she was already helping him up into his car, so I didn't really get to see what he looked like.
All right. Did you help him into the car?
No.
Do you know if Jacob Miller helped him in?
I don't think Jacob did.
Okay. And do you know if Joe Murray helped him into the car?
I don't remember.
Okay. At that point, what happens?
At that point, they get into their car. I believe she had taken him to the hospital, and me, Joe, and Jacob walked back to the parking lot, and I got my kids back on the van, and we left the arch.
All right. And you've been interviewed a couple times after this by the police department. Is that correct?
Yes.
All right. And you were also contacted by an individual named Alonzo Hickerson. Is that correct?
Correct.
When were you contacted by Alonzo Hickerson?
I don't know the exact day, shortly after the incident occurred.
Okay. And what was the nature of that? Was it by phone?
Yes.
What was the nature of that conversation?
The initial conversation, the initial reason he was calling me had to do with basketball. I don't remember what exactly about basketball. We're both coaches, we coach at a prep school, so we talk about basketball topics all the time.
Was there any discussion about this incident?
Yes.
What was that discussion about?
It initially started with him asking me if I had heard what happened.
Okay.
I responded telling him I had heard what happened. At some point in the conversation, he had said something along the lines of, I don't know the exact words or verbiage that was used, but he had made a comment about what I saw, and he asked me if I had seen the Morris brothers beat up the gentleman that got beat up.
Okay.
I initially, go ahead.
Go ahead.
Initially responded saying no. And then he continued and said something along the lines of, well, if you give a statement saying that you seen or saw the Morris brothers get beat up, the gentleman get beat up by the Morris brothers, the gentleman getting beat up is going to receive a settlement, and you will receive some kind of compensation / money, something like that.
Okay, so what did that mean to you? What did you believe that he was trying to encourage you to do?
Give a false statement.
All right, and had you already talked to police at by the time he made that call?
I don't recall. I believe it was before I talked to detectives, but I don't remember if it was before or after.
Okay, and in response to that, did you indicate to him anything about that?
Never. I initially shot down the idea. I told the gentleman, Alonzo, I have no interest in giving a false statement. I tried to laugh it off, honestly, because I was shocked that somebody would ask me to do something like that. So I tried to kind of play it off. You know, when you're in a conversation and someone brings up some kind of crazy idea, I try to quickly change the subject and veer away from the situation and told him I wasn't interested.
Okay. So did that influence any of your statements to police?
No.
Did that influence any of your statements here in court today?
So that was some of the testimony from earlier in the case, where you've got this guy who was part of the tech crew at this youth football game where many of the accused attackers and the victim were all present together before this assault happened. And he's saying that one of the associates of the victim asked him to lie about the case. So that's really the most explosive part of this that came out. Marci, do you agree?
Yes. And, what would be his motive to lie? Why would he?
The money. They're trying to say that the victim's going to get this. Look, the victim is asking for a $7 million payoff, basically, from the Morris brothers for chasing him, hitting him, and punching his nose. That's what he claims. Okay, right. Breaking his nose. Now, I don't know about any other jurisdiction where I've ever been, but Marci, in Phoenix, Arizona, is a broken nose worth $7 million in tort recovery?
I don't believe so, unless it's a very special nose. That'd have to be like perfect.
Yeah, exactly.
Or trademark.
So the expectation is just astronomical, and the fact that the victim is even, admitting that he's looking for no less than $7 million to drop the situation is laughable.
Well, and the other thing that's kind of just ill-informed is oftentimes people mistakenly believe that they have the power to make charges go away. So, once you call the police get involved and the state steps into the shoes of the victim no longer, or the alleged victim, they don't have the ability to say, okay, I'm going to drop it. They could ask the prosecutor to drop it. They could come forward and say, I'm lying. But once the state takes it, it's the state's. And so they will pursue it.
Yeah.
They can't make it go away just because it settles.
Exactly. Now, I want to ask another question here, and this goes into some of the local practice here, but the victim took some heat for even filing this civil case against the Morris brothers, but apparently he took a year and a half to file it. Now, to me, that doesn't seem suspicious, but one of the other local attorneys in Phoenix who was here on LawNewz yesterday said that it can be used to color his testimony. So do you have a sense of what the local practice is there? Because in many jurisdictions where I've worked, the civil suits are filed pretty quickly, regardless of the outcome of the criminal case. Do you think we can read anything into that?
No, and well, yeah, I think so, actually. I don't know about the civil stuff, but that seems really suspicious to me. I mean, it's not like it happened and they didn't get a diagnosis for a year and a half later. They knew exactly what happened and when it happened. And so it would suggest to me that they were holding it back in order to get some kind of payout. I mean, there's all sorts of stuff that you could read into that, right? Like, you're extorting these guys for money with the threat of a lawsuit.
Well, and it could also be a statute of limitations thing too, and that's something I haven't had a chance to look into. But if the statute of limbs is, 18 months or 2 years or something, clearly they'd want to get it in before the limitation is up. So, I was just curious as to your thoughts on that. What do you make of the state's lead detective, the Phoenix lead detective, saying that when he showed up to interview the Morris brothers, they claimed to not know the victim at all? But yet we have photos that we've had on the air here on LawNewz of them all together long before this attack happened.
Long together how, though? I mean, because if you're saying, I don't know somebody, are you saying, we're not friends, I travel in the same circle with this person? So you could recognize someone or be an acquaintance and not really know them. And so I'd have to understand the context, how that was said to the detective. Like, I don't know this guy from Adam, never seen him before, or I don't really know him.
I agree, and I oftentimes wondered the same thing yesterday. So it's a question of how well he may have been known, but I'm sure the state's going to try to color that and say the Morris brothers were lying about knowing the guy in order to throw the police off their trail.
Right. Well, and where did those pictures come from? Because, I mean, did the police have the pictures of the victim and the brothers together? Were they aware they existed?
They're floating out there enough where we've seen, I think we saw a few of them in court because we have them and we captured them from the court feed. So they've been submitted, they're in evidence in some fashion, but the picture doesn't tell the whole story. I mean, professional athletes are always having people come up to them or go to signing events or some sort of a thing where they're having their photo taken with every Joe and Jenny who comes in off the street. So I don't know all of the context. Maybe they were spotted in a club or a bar or a restaurant or whatever. I'm curious to see how those may or may not be attacked. So, leads me to another question here. Phoenix police are claiming, and then therefore the prosecutor is claiming, that this attack was the result of some text message or phone call or a series of both between the victim and the mother of the Morris twins, and that apparently set off the charge that led to the attack. That's what the state is claiming is a motive here. Now, the lead detective said that no attempt was made to subpoena records to actually get the text message that they are hinging this attack on. It reeks to me of sloppy police work, and I'm just wondering what's up with the Phoenix Police Department.
Oh, it's totally sloppy police work. I mean, come on, where's this, like a screenshot, anything? Can you show us anything that supports this claim of these things? It seems like you should get something, but you got to remember that in Arizona, the jury's going to get an instruction that says motive doesn't matter. And the state need not prove a motive. And so that may have been factored into the decision about, do we try and substantiate these claims?
Well, yeah, but still, if the state's going to get up there and argue that it exists, and the state has admittedly thrown all of this time and attention on this investigation, the detective said, I have not seen another case where right from the outset I was given a carte blanche, overtime, whatever I needed to try to get these Morris brothers pinned down in this case and get it figured out. Not every punch to the nose that results in a broken nose investigation gets that amount of police resources thrown at it, and yet that's what happened here, but yet they don't have the text message.
Right. And you know what? You got these famous guys, so there's a lot of pressure on the county attorney's office. How many county attorneys were trying this case? I thought when I was in the courtroom there may have been 3 lawyers at the county attorney's table. Do you know how many county attorneys were there?
I have only primarily seen one argue, but a lot of it's because our camera is only on the witness stand, so there may just be other voices that I have not picked up on. But I thought it was one.
I think an inference can be drawn here that, look, I mean, like, this is a high-profile case. They have certainly used a lot of resources to bring this case to trial. This case is going longer than any normal aggravated assault trial should go. If that evidence existed, they probably would have found it. The fact that they haven't presented it, I think allows one to draw the inference that it might not exist at all. It never did.
Yeah, I'm really curious to see how they're going to go on this. Well, we should be back into live testimony here within the next few minutes. Marci Kratter, criminal defense attorney from Phoenix, Arizona. Good to see you. This is your first Law News appearance, and hopefully you enjoyed the conversation.
I loved it. Thank you for having me, Aaron.
Okay, we'll hopefully